What if I told you that you could build a well-known brand, file a trademark, and still not actually own it? And worse, you might not realise there's a problem until a dispute lands you in court. That's exactly what played out in a recent federal court case. The case of Blackstar Pastry Proprietary Limited and Richards, No. 2, 2026 FCA 383. And today we're unpacking one of the key issues in trademark law. Who should actually be listed as the owner when you file a trademark? Because getting this wrong isn't just a technical mistake. It can undermine your entire protection strategy. Welcome back to Elise Explains IP, where we make intellectual property practical, strategic, and actually useful for business owners. Today's episode is a case study with a very clear takeaway. Trademark ownership is not admin, it's fundamental. Let's dive in. At a high level, this case involved a dispute around the ownership and control of branding associated with Blackstar Coffee. The key issue wasn't just whether the trademarks existed, it was whether they were owned by the right party in the first place. The court had to look closely at who was using the brand, who controlled the brand, and critically, who had the right to apply for the trademark at the time of filing. Because in trademark law in Australia, ownership and the entitlement to apply for a trademark is assessed at the time of filing, and it can't be fixed later. So, here's the rule that sits underneath all of this. The applicant for a trademark must be the true owner at the time of filing. That usually means the entity actually using the mark, or could be the entity controlling and intending to use the mark. And importantly, if the wrong party files the application, it can be vulnerable or even invalid. This is not something you can always clean up later with a simple assignment. The issue comes up far more often than people would expect. Common examples include a founder who registers the trademark personally, but actually has a business that operates through a company. Multiple founders are involved, but only one is listed as the owner of the trademark. Or a trademark is filed before the business structure is properly set up and they haven't really decided who's going to be using it. At the time, these decisions feel minor, but legally, they determine who owns one of the most valuable assets in the business. Now, one of the most interesting parts of this case centered around the Blackstar Coffee trademark. And once again, it seems to be the coffee industry giving us some of the most useful trademark lessons in Australia. Because this wasn't a situation where no one thought about protection. A trademark was filed. A trademark was granted. The trademark was registered. The issue was who filed it. So, what actually happened? The Blackstar Coffee mark was filed in the name of one of two individuals involved in the business. So on paper, you had one person equaling one registered owner. But in reality, the brand formed part of a broader business involving more than one party. And why does this create a problem? Trademark ownership isn't about who came up with the name, who filed the application, or who paid for it. It comes back to a more fundamental question: who owns the goodwill in the brand? And in a business context, that usually sits with the business entity itself, or the parties jointly carrying on that business. So when one individual files a trademark personally, you get a disconnect between the legal ownership, what's registered on the register, and the commercial reality, how the brand is actually used. The court needed to assess whether the individual who filed the trademark was genuinely the owner at the time of filing, or was attempting to claim exclusive rights over something that was jointly developed and used. That analysis becomes very fact-specific. Who was operating the business? Was there a partnership agreement? How was the brand being used day to day? Were there any agreements about ownership? Because if nothing is documented, the court is left to reconstruct the intention from conduct. This is a very familiar scenario in early stage businesses. Two people start something together, one person handles all the admin, and the trademark gets filed in their name. No one thinks much of this at the time. It happens all the time. But legally, what you've done is allocate the ownership of a key business asset to one person, whether you meant to or not. If things later change, as they often do, this can create some real problems. One party might claim exclusive ownership, the other party will have to argue that it was always shared, and the business itself may not actually own its brand, which affects licensing, franchising, the sale of the business, and will probably turn up in investor due diligence. The key takeaway from this Blackstar Coffee issue is simple. You don't just need a trademark, you need the right owner on the application. Because their trademark was actually held to be invalid, and therefore they lost their infringement case. And specifically, if it's a shared venture, the ownership must reflect that. If it's a company business, the company should own the trademark. If multiple parties are involved, you need to document it clearly before filing. If you're listening to this and thinking, I filed the trademark myself, and there were other people involved at the time, and we never really discussed ownership. This is exactly the risk that this case highlights. It isn't just a legal theory, it has real consequences. Blackstar Coffee sued for trademark infringement and found themselves without a trademark at all in the end. If the ownership is wrong, you may face trademarks that are vulnerable to removal or invalid, which leads to difficulty enforcing your rights, and problems selling your business, potential issues around investor due diligence, and potential internal disputes between the founders. In short, you may think you own your brand, but legally, you don't. Here's how to approach this strategically. 1. Decide on ownership before filing. Ask, is this a personal brand or a business asset? Am I looking to scale or get investors in the future? In most cases, the company or the partnership or the business entity should own the trademark. 2. Align ownership with use. The entity controlling and commercializing the brand should generally be the owner. 3. Avoid early-stage shortcuts. Quick filings and DIY approaches are where most of these issues start. 4. Document relationships clearly. If there are different entities involved, make sure you put license agreements in place and clarify the ownership upfront. 5. Think strategically, not just procedurally. Trademarks sit within your business structure. They need to be considered in your asset protection strategy and in your exit planning. If you take one thing from this case, it's this. Getting the name on the application wrong can mean you never had a valid trademark to begin with. And by the time that becomes obvious, it's usually because there's already a dispute. So, before you file your next trademark, or even if you already have one, ask yourself, is it actually owned by the right entity? Because as this case, and once again the coffee industry is showing us, trademark problems don't come from not filing. They come from filing in the wrong name. If you'd like help reviewing your trademark ownership or aligning it with your business structure, you can book a strategy call via my website. And thanks for listening to Elise Explains IP. And I'll see you next episode. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.